for making the bail order. Yes.
Consider reasonable involvement of the accused. Even at the stage of considering the bail, section 37 of the NDPS Act, it envisages that the court has to consider the aspect that there is a reasonable involvement of the accused or not. We can consider the documents of this case diary.
Because in this case, the CCTV footage and CDR details indicated the case was absolutely fabricated.
Yes, you can consider the bail.
Issue here is, at times, I am not saying all the time, at times, when such things happen, whether the courts will remain silent, I am not saying we will bring in activism. Yes,
sir.
Mike.
Similar matter that you just raised.
Yes.
The remand was, he was just given conditional remand for 2 days, and they were directed to produce all the CCTV recordings because this is exactly the situation that had arisen. And he had an alibi. He was not even there, and the police framed him basically by planting all the stuff on his with him. तो रिमांड में जब हुआ, मतलब इट वाज टेकन, मतलब बहुत बड़ा उसमें एक्शन लिया गया उसके बाद में, कितना रिमांड ही रिफ्यूज हुआ उसके बाद में आफ्टर 2 days. वो तो बेल की बात है, वो तो रिमांड ही रिफ्यूज कर दिया.
Yes. मतलब if at the stage of remand we find के palpable illegality has been done, तो फिर नहीं तो अगर हम if we become permissive or say if we don't act, in that case we become a part to it basically.
Sir, see, the question is, serious question is concerning right of personal liberty of a particular person. If it can be done at that stage, why to wait for the trial to begin?
Yes. So we should not expect that everyone will go to High Court or Supreme Court. So liberty of people is in your hands. And regarding bail, please, I hope all of you must have visited some jail or the other for inspection purpose. Do visit jail. I had visited in my posting of State Human Rights Commission, Indore jail. People cannot take a turn like this. If they are like this, they cannot be on their back. And if they are on their back, they cannot take a turn like this. So jails are already overcrowded. I am not saying that we should give bail to everybody, but in appropriate cases, people have to be sent inside.
Sir, if you kindly permit, after some time, I would like to quote one case which has actually
My rhythm is not affected actually. Please do narrate so that everyone gets benefited.
yes.
Please face the audience and
No. Just sharing.
Actually क्या होता है जब करते हैं ना वो उनको सुनेगा नहीं ठीक से. Please face the audience and tell them.
Yes. It was a case which has actually changed entire narrative. At that time I was practicing advocate, and in the evening one of the senior advocate was going back home. Somebody threw तेजाब on him. एसिड अटैक हुआ, पूरा एक साइड से पूरा आँख वगैरह पूरी चली गई. There was too much anger in the bar association. All the advocates stopped working. Then there was much pressure on police. And after 3 days, one builder and four of his colleagues were arrested. Remand was granted. Articles were seized. Acid and all that, bottles and all that, they were seized. Then bail applications, they did not get advocate from our bar, so they had to bring it from some other district. And thereafter, bail applications were rejected. Police came with the case that there is sufficient evidence which shows their involvement in the crime. After 3 months, that was time to file charge sheet. Investigation was about to be over. On railway station, one thief ran away with one pav. RPF personnel chased him for 1 kilometer. He was drunk. RPF personnel started beating him. तो बोला साहब इतना बड़ा कांड कर दिया, अभी तक हमको पकड़ नहीं और ये बन पाव के लिए आप पकड़ रहे हो. तो बोले क्या कांड कर दिया? तो बोले वो वकील पे तेजा फेंका ना. So he brought, immediately SP of the district was called. Then he narrated entire story, who were involved. 5 अलग लोग थे. उसने वो गोदाम भी बताया जहाँ पर वो आर्टिकल छुपा के रखे थे, कंसील करके रखे थे. Second day, police came to the court, filed application. These are not the accused. These are 5 accused. 3 months. Those 5 persons who were not involved in the offense, they were lingering behind the bar, and it has affected their family. They were completely destroyed. And thereafter, what happened next? These persons who were actual culprits, when they applied for the bail, they brought the copies of MCR and say filed by the prosecution. And when again police said that there is substantial evidence against them, they said कि पहले भी ऐसी बोला था आपने. See what happened. What if after some days some other persons are caught? On that ground, on the 7th day only, they all were released on bail. So this is that time I felt that we need to be really very cautious, very sensible, because it affects a person's life, his family's life. So no bail cannot be a principle. So what sir was saying, why not at the stage of bail, we should call for the data if he is able to show that he was not there at all. So why to wait for the trial? Thank you, sir. Thank you so much.
Thank you very much for sharing. In some of the places, I am not naming the states, these sections, the Explosive Substance Act and NDPS Act, these have been used as preventive sections so that we can detain them for a longer time, because bail will not be granted easily. But that is not the purpose of the legislation. So ultimately, it burdens the already the overburdened system of courts and jails also, because it will require time during trial. आप लोगों का भी उसमें ट्रायल में तो समय लगेगा ही, so that time will be wasted. और किसी के पास ऐसा कोई एग्जाम्पल जो हम शेयर कर सकें बाकी के साथ में? मैंने एक ये और सेक्शन है, सेक्शन 62, इसको यदि हम ध्यान से देखें, what it says, no arrest shall be made except, the word here is except, in accordance with this Sanhita or any other law for the time being in force providing for arrest. So the key word is here is no arrest and shall and except. Jogendra Kumar and D.K. Basu guidelines we have already discussed. What is this case relating to Neelbati Behra? Someone from Odisha? Yes? Custodial death? Neelbati Behra was the mother of the deceased. His name was Suman. What happened in this case? How the matter reached Supreme Court? Article 32. what happened during the trial of those police officers? Because I followed up to that, this case up to that extent. Yes. The case was registered, investigated, but what happened to the case? So you don't find it in the citation. Yes. The criminal case was registered, but what happened? The case was finally reported. Police officers were on call. I was looking for the order sheet of that case actually, but somehow I didn't get it from the outside. That case from Madhya Pradesh. Again, Justice Anand was one of the members of that bench. So it was a case of custodial death, and they tried to एक पुलिस के जब हम लोग केसेस को इन्वेस्टिगेट करते हैं तो बाय नेचर दे आर नॉट क्रिमिनल्स. So once it comes to commission of crimes, they leave a huge trail actually, and which is picked up very easily. तो किसी नाथू बंजारा को ये पकड़ के लाए थे श्याम सुंदर त्रिवेदी वाले केस में, पर जब वो डेथ हो गई तो उसका अननोन के नाम से इंक्वेस्ट कर दिया. तो जब लेके नाथू बंजारा को आएंगे तो हिसाब तो नाथू बंजारा का ही होगा, अननोन का थोड़े होगा. So they were convicted by the Supreme Court. And Article 21 we should always remember that it is the fundamental law relating to liberty. This handcuff we had discussed. The details are here. Who is habitual or repeat? Repeating the same offense. Repeat is in context with the same offense. Habitual is can have variety. Escape from custody. So now they have categorized those cases where handcuff in, but still the keyword is what? Keyword is here. May. It is not shall. They can still not use it in appropriate cases. What is discretion? Or what is a legal definition of discretion? Yes? Two options. What else? Yes. Judicial application of mind, not arbitrary. So reasonable, we had discussed those Wednesbury principles from administrative law. Whether it still covers the remaining part of the ratio of citizen for democracy versus state of Assam. Let us see what it says. While arresting and while producing. The word prison or jail is not mentioned here. It will be covered or it will not be covered. Citizen for democracy versus state of Assam में क्या रेशो थी? Place of arrest to police station to court. These two are covered here. But whether from court to jail or jail to court is covered in this provision. Yes. Let us see the opinion of the House in this grey area. Can that definition will be extended to that? Necessary implication, yes. What else from interpretation of statutes? What else? penal statutes का construction कैसे होता है? Strict or liberal? If we are saying, say, it will extend to that, the word jail or prison is not mentioned here. Let us read it again. What it says.
words, first of all. Now, a production, question of production arises.
Actual sentences while producing before the court.
Yes, obviously. After arrest, we can produce.
Yes.
From jail, we can produce. And from what I called shown arrest, is detained in another custody, we can produce. But here, the question of production from jail or in case of shown arrest, police is not the responsible authority to produce, but the jail authority, that is prison department, is likely to produce by providing escort from jail to court.